So today we are going to discuss about the nature, scope, origin, and development of law of torts, and also the role of the writ system in its evolution. So the law of torts is one of the most dynamic branch of common law. It is a branch of common law. Unlike other legal subjects like contract, criminal law, it is fundamentally judge-made law. It has been built piece by piece over centuries through the judicial decisions rather than a single legislative code. It is totally on the basis of judicial decisions, judge-made law, and it is called as the common law. It is a branch of common law. The nature and scope of law of torts. The word tort is derived from a Latin term tortum. So what is meant by tortum? Tortum means twisted and or it can be called as crooked in legal terms. A tort is a civil wrong other than a breach of contract or breach of trust that causes someone else to suffer loss or harm, resulting in legal liability for the person who commits the act. So word tort is derived from a Latin word tortum, which means twisted, crooked, or it can be considered as in legal terms, tort is a civil wrong. It is unlawful act. So that causes someone else to suffer some loss, some harm, resulting in a legal liability for the person who commits the act. Next, the nature of tort law is characterized in three core legal elements. So, what are the three core legal elements? Civil injury, unliquidated damages, right in rem. So, it is a wrong against an individual or private entity, not society as a whole, which constitutes a crime. So here the injured party initiates the civil lawsuit. So it is known as a civil injury. It is a wrong against an individual or a private entity and not at all against any society or any as a whole of any society. So the injured party initiates the civil suit. So the next one is unliquidated damages. Unlike a contract where the penalty for breach is often predetermined one. Already it is said to be determined. But here the damages in torts are said to be unliquidated, meaning the court determines the compensation amount based on the actual harm which is said to be suffered. So the third point is said to be right in rem. So what is right in rem? It protects the rights that you hold against the world at large. Your right to personal safety, your right to enjoy your property, rather than right against a specific contracting person. So right in personam. So this is said to be right in rem. So it protects the rights that you hold against the world at large. Example, your right to personal safety, your right to enjoy your property, and not rather than the rights against a specific contracting person or right in personam. So the foundational maxims governing its nature. The legal nature of injury in torts is dictated by interaction between the actual damage and legal infraction summarized by historic maxims, two historic maxims. One is injuria sine damno and damnum sine injuria. So, what is injuria sine damno? Injury without damage, that is legal injury without damage, a violation of a legal right without causing any actual physical harm or financial loss. This is actionable in court. So, example, you can write Ashby versus White, 1703, where a voter was wrongfully blocked from voting, even though his candidate won anyway. So, this would be the applicable case. So, in damnum sine injuria, damage without injury. So, actual substantial loss or harm caused without the violation of a legal right. So, this is not actionable in court. Example, so Gloucester Grammar School case, 1410, where a schoolmaster opened a rival school next to an established one, causing massive financial losses through competition, but violated no legal right. What is the scope here? So, the scope of tort law explores its boundaries. It is it a unified theory, or is it just a collection of random historical boxes? This is characterized by two conflicting academic theories. So one is said to be the Winfield theory. So here the law of tort. Sir Percy Winfield argued that all injuries done to another person, all the injuries, all that injuries, or all injuries done to another person or tortillas unless they can be justified by law. According to this view, the court has the power to create new torts whenever a novel injury occurs. So likewise, Salomon's pigeonhole theory. So Sir John Salomon fiercely disagreed, asserting that there is no any general principles of liability. Instead, there is a specific set of closed independent wrongs. A plaintiff can only win if they fit their grievances into a pre-existing labeled pigeonhole, like assault, battery, or libel. So the modern application sits in between. While courts rely on specific established elements, according to Salomon, or they regularly expand liability to address modern developments, according to Winfield. And the origin and the development of torts law. The historical development of tort law evolved through four distinct epochs. Epoch 1, the Anglo-Saxon era. So, before the centralization of English state, local systems administered the justice. So, liability was strictly bought based, accrued tariff system mapping physical injuries to mandatory monetary compensation, whereby it had a strictly bought based system. If you broke a man's thumb, you paid a set amount of shillings to his clan. So the primary goal was to avoid violent family vendettas. Intent did not matter. If your axe slipped and hit someone, you paid. But the next one is said to be the post-Norman centralization, that is 11th to 17th century. Following the Norman conquest, King Henry II centralized justice via royal judges traveling on circuit. So the focus shifted from clan peace to the king's peace. So here, wrongs involving violence were categorized as breaches of this peace, drawing them into the jurisdiction of royal courts. So this period was dominated entirely by the rigid mechanics of the writ system. The third one is said to be the Industrial Revolution, 18th to 19th century. So the dawn of steam power, textile mills, the railways, dense urbanization completely broke the old frame of intentional torts. So society suddenly faced thousands of injuries that were completely accidental but utterly devastating. So the law shifted its core focal point from intentional physical violation to unintentional faults. So courts rapidly expanded the principle of negligence and vicarious liability, holding factory owners responsible for the mistakes of their employees. The House of Lords unification, 20th century. So until 1932, negligence was limited to specific relationships. Example, a doctor to patients. So if your situation did not have precedent, you couldn't sue. So this arbitrary limitation was dismantled by the landmark decision in Donner versus Stevenson, that is 1932. So the famous snail in the ginger beer case. So Lord Atkin formulated the universal neighbor principle. So you must take a reasonable care to avoid the acts or omission which you can reasonably foresee would be likely to injure your neighbor. So this monumental ruling shifted torts law from a disjointed list of actionable wrongs to a unified system rooted in public policy and also the foreseeable duties of case. So the role of the writ system in its evolution. So to understand the modern tort law, one must recognize that its concept does not emerge from abstract definition of justice, but one of the machinery of medieval English procedure. So the history of tort law is identical to the history of the writ system. So the mechanism of the writ. A writ was a formal document issued in the king's name by the chancellor, ordering a local sheriff to bring a defendant to a royal court to answer a charge. So the system was strictly procedural. Form preceded substances. If a plaintiff chose the wrong writ, their case was thrown out permanently. So whereby, regardless of the moral, factual merits of any injury, so the plaintiff suffers harm and also applies to the royal chancellor, which writ applies to the injury. So direct forcible violation or indirect consequential injury was faced. So if it is direct forcible violation, a writ of trespass, indirect consequential injury, it is writ of case. So in case of writ of trespass, actionable per se, kept king's peace, direct force applied. So in the same way, writ of case must prove actual damage, so which has covered omission and indirect acts. So the two foundational writs shaped the entire architectural framework of a modern tort law. So one is the writ of trespass, wage armies, so emerging in the late 12th century. So this writ applied exclusively to actions executed with force and arms, wage armies against the king's peace. So it branched into three distinct actions that remain virtually unchanged today. So one is trespass ad personam. So the modern assault, battery, false imprisonment. As like that, the trespass de bonis asportatis means the modern conversation and the modern conversion and the trespass to goods. So here trespass square clausum. So frigate means modern trespass to land. Trespass where clausum frigate means the modern trespass to land. So the writ of trespass on the case, because human interactions are complex, so the requirement of direct physical force meant many egregious wrongs or any kind of wrongs went unpunished. So in response, the Statute of Westminster 2, 1285, empowered the clerks of the Chancery to issue new writs in cases that were structurally similar to existing ones in consimile casu. So this yielded the trespass on the case, later referred to simply as case. So this writ captured indirect, non-forcible or consequential injuries. So to understand the operational differences between the two primary writs, the legal historians took two classic distinction established in the early English case law. So the highway analogy. Reynolds versus Clark, 1725. So if a defendant throws a log out of their window directly on to a pedestrian walking in the street below, that is trespass. So the force is direct and it is said to be immediate. If the defendant throws the log into the street, leaves it there, and a pedestrian later trips over it in the night and breaks their leg, that is a case, the force is spent. So the injury is indirect and consequential. So critical distinctions introduced by the writ of case. So the requirement of damage, unlike trespass case, was not actionable per se. So the plaintiff had to explicitly plead and prove that they suffered actual quantifiable loss, damnum. So the damage was the fundamental substance of the action. So the absorption of omission, while trespass required an active, forceful, misfeasance case, allowed courts to hold individuals liable for non-feasance, failing to act when there was a duty to do so. So paving the way for the modern framework of negligence. So the legacy of the writs, the formal procedure writs were completely abolished by the Judicature Act 1873 to 1875, again, which was again replaced by the specific writs with a single writ of summons stating general claims in plain language. So, however, the structural division created by the medieval writ system remains deeply embedded in current common law. So, writ of trespass, always it is said to be direct, forcible interface with person or property actionable per se. Assault, battery, false imprisonment, trespass to land. and it is always intentional to plaintiff to prove act. So, a writ of case, indirect consequential harm resulting from actions or omissions. So, negligence, nuisance, as well as the defamation, deceit. So, as the famous legal historians F.W. Maitland famously observed that the forms of actions we have buried, but they still rule us from their graves. So the modern tort law is essentially the continuous refinement of these two historical streams, balancing direct intentional wrongs against the indirect careless harms.